All right, well, welcome back to Legal Lunch Break. Today we're having a conversation with Mike Imprevento. Mike is a law partner of mine and a mentor, but he's taken on many different titles in his life and many different roles. So, Mike, go ahead and introduce yourself and give us some background.
Thanks, Kevin. Well, within the last year or so, while in the firm, I went and sort of kept a promise that I made to some police officers that I represented in the past. For years, I was a lawyer for police, and some of them were killed in the line of duty. And I thought, you know what, and military that I represented are gone. And I thought that I would do something difficult in their honor before I couldn't anymore because I'm getting old. So I became a sheriff's deputy in the Commonwealth of Virginia. I'm sworn. I went through their academy, and I serve as a staff attorney for a local sheriff's office. I'm intimately involved in the issues that we talk about now, and also continue to associate with the firm on sort of an of-counsel basis because I enjoy coming out here and being with you guys occasionally. But my primary role right now is to be involved in the issues that face a modern law enforcement agency, particularly in the wake of the tragedy in Minneapolis.
And even before all of that, you were involved as a JAG officer as well and kind of went to private practice and then found your own current role.
Yes, exactly. I started my career as a judge advocate in the United States Navy, and interestingly enough, issues of discretionary function and governmental sovereignty came about when I was involved in the claims division of the local legal service office, and also served as a special assistant United States attorney. So for most of my life, I've kind of dealt with these issues.
Yeah.
And I noticed that recently, and there's been some discussion of modification of some of these traditional doctrines because of the tragedy. And I think for a while there's been some discussion about whether or not people perceive that government actors are unduly protected.
Yeah, and I think we talked about it before we jumped on, but I mean, obviously, in the face of what's going on in the world today, there's been the discussion of qualified immunity.
Oh, yeah.
And we have our similar views in some ways and different views in others, but you have a different perspective.
Yes.
Where you are now. So I'm curious, and we can dive into the details of qualified immunity, how
Sure.
it applies, but I'm curious what your take on it and how it applies kind of day to day in the practice of police officers and law enforcement.
Yeah, it's, well, I can tell you that there's been an awful lot of introspection, because I think in the context of qualified immunity, there's not a police officer in the country, or a deputy sheriff for that matter, that would look at the tactics utilized in Minneapolis and say that they were permitted, to say that they were used or taught or in any way are part of modern American police practice. They're simply not. But we understand that our actions are going to be scrutinized to a different level. And not only, of course, law enforcement in this country on the cutting edge in terms of primary law enforcement are the police and deputy sheriffs. But there are many in law enforcement that aren't involved in primary law enforcement, but are involved in as jailers, correctional officers, civil process servers. So there's various aspects of law enforcement that may be attacked with a broad brush. And there is a lot of concern about that we have an unfortunate tendency in this country when we see a tragedy to immediately run to legislative fixes that are not well thought out. And it turns out that many times they do not confer the protections that were thought, and they wind up having an adverse effect. So I hope that there's mature consideration about the applications of qualified immunity at both the state and federal levels, because there's a lot of talk about, a broad brush abolition of something that's been, I don't know, I think the judges kind of carved it out a long time ago.
Yeah, and I mean, I think for me, the other side of that is right now it seems like qualified immunity, just as you're saying you don't want a broad brush that gets rid of it, right now it seems like a broad scope that's covering more than it ought to, right? I mean, it started in the 60s.
Yes.
It started in 1967. I think we talked earlier
Yes.
about this good faith basis for police officers and what they're doing, and how does an officer know they're acting within the law or without the law.
Right.
unless there's some sort of clearly established rule, which is where all the law came from. But now you have situations like we've seen in Minneapolis or other situations that have come through the courts where it may not be clearly established law, but it's clearly wrong. And so how do I think that's the concerning part for me is you have something that's clearly wrong, and then you're concerned about whether it was wrong before in order for them to be held responsible.
I've been thinking about it because, you basically resign yourself to the inevitability that there's a call to action and it's probably going to happen. And I've looked at the cases, and quite frankly, even from my standpoint of having undergone force on force training, having undergone defensive tactics training, I find it very hard for any court in this country to say that qualified immunity applies in a use of force case. The circumstances of deadly force are well settled in the state law. We all know without a reasonable fear of death or serious bodily harm, you can't use deadly force. In terms of physical force, policies and procedures and the cases, I think it would be the rare case where an officer or a deputy sheriff wouldn't know what line is crossed in that regard. So I think that we're going to throw out a lot of reasonable protections when we're seeking to stop one thing, and that is most probably excessive uses of force that tragically sometimes result in death, which I don't know ever were a really good candidate for qualified immunity.
Yeah, and I think just to clarify, I think and correct me if I'm wrong, what you're saying is qualified immunity applies to many circumstances, not just the use of force by a police officer.
Absolutely.
And in the circumstances where an officer is using force, and if it's excessive or not, if it's the use of force, the law or the standards are so clearly established, even without case law, that qualified immunity probably shouldn't apply. Am I understanding what?
Yes, I think it would satisfy, because again, I think it would satisfy the detractors and those who are concerned that it's a blanket protection. First of all, it's not. Qualified immunity is denied as often as it's granted. I think there was a statistical analysis that was done by the Cato Institute that, frankly, has taken an aggressive position against it, and is urging in amicus briefs the Supreme Court to grant cert in some of the pending cases now. But I find it really hard to believe that in a bare use of force case, which is the one that has caused the call to action, that there would be a judicial analysis that was not clearly established to the officer or deputy sheriff.
But I think the problem is that it happens, though. I agree with you. I think we're saying the same thing, where you can't imagine a situation where a use of force isn't somehow described as not wrong prior to the action. So in other words, it's contrary to training, or it's contrary to what they already know.
Right.
But I think in the decisions of different courts, it's gotten so narrow where certain circuits, just a separate circuit, let's say the 6th Circuit or the 11th Circuit, is just deciding what's clearly established based on their own case law. So they're not taking into account the training that you got as a police officer that should have educated them that you're not supposed to do X, Y, and Z.
Right.
They're just taking into account what have the courts established as clearly established unconstitutional wrongs, rather than what have these police departments established as poor policies and procedures and practices. That's where I think it's getting skewed in the system, because an officer can say, yeah, sure, I've been trained not to do this, but there hasn't been a decision that finds it unconstitutional, and therefore I'm out.
Yeah, that's not what should be done, because I think that we can satisfy the concerns of Americans that believe that a police officer should not be granted qualified immunity for something that just appears, like you say, absolutely wrong.
Yeah.
Training, and now I can't speak to all levels of training in the country, but most police academies that are putting people on the street, most in-service training where it's like our CLE,
Yeah.
is basically constitutional. It's national. It's not local. It's not the Commonwealth of Virginia permits a certain level. There's a tremendous commonality between deadly force doctrines, common law, statutory law in the various states, at the federal level. It's basic training, and when you can put your hands on somebody, when you can't put your hands on somebody, and it's hard to believe that in many instances, qualified immunity would be brought to bear to protect someone from what clearly is a use of excessive force. My concerns are that a blanket abolition would draw in those truly gray areas that officers act in good faith on, and that deputy sheriffs act in good faith on. And obviously, you set the tone for this, and at a certain point in time, I'd like to give some examples.
Yeah.
And then, we can discuss it. But obviously, you tell me when you want me to do that.
Yeah, we can discuss that, because I think, and we talked about it before, and we can go. Let's go through some examples.
Sure.
But my thought on it is, overcoming qualified immunity for a plaintiff or someone bringing suit isn't, the victory, right? It's just the opportunity to have your case heard on the merits, right? So you're not it's not, if we got rid of qualified immunity, it's not saying that there won't be a defense on the merits that an officer used good faith. So, but I'm curious to see what your examples
which is
are.
why I think in the excessive force setting, which is what brought the focus to it, that makes sense, because the officer and the officer's employer can say that it was reasonable under the totality of the circumstances.
Yeah.
When it gets hyper-technical, though, let me give you an example of how it's come out in the country recently.
Okay.
And it involves federalism. It involves the interplay between federal authorities and state authorities when it comes to the enforcement of immigration law. Now, in Arizona versus United States, it was pretty much state officials cannot primarily enforce immigration law. But it generally comes through the vehicle of a federal agent asking for cooperation from the state agency, and that's permissible. They said that in the case. So a good faith police department or correctional facility holds someone based on a piece of paper they get from a trained federal agent, an ICE detainer. It says, at the time that this individual, we have probable cause to believe this individual is subject to removal from the United States. It's a certification of probable cause, non-judicial, but a trained agent has certified probable cause.
Administrative agent.
Yes, it's basically a senior ICE agent would say, I have probable cause that this person is subject to removal. I'm asking you to hold them a reasonable time after the state charges so that we may come and get them.
Okay.
This has caused a tremendous amount of controversy throughout the country, because any place that cooperates with the federal authorities is seen as
this is where all the sanctuary cities.
Exactly. The sanctuary cities have policies of simply not cooperating, not holding, and releasing people that unfortunately have committed crimes. From a law enforcement perspective, you want to cooperate with the federal authorities, and the Supreme Court has encouraged this, that immigration law is that way. Well, suits have been filed against good faith jailers and correctional officials around the country saying that you lost the authority to hold me when the judicial sentence was up, and you're holding me on the basis of either no probable cause or invalid probable cause without any judicial oversight. This is simply an administrative situation. Well, the Fifth Circuit Court of Appeals upheld a law which commanded that ICE detainers be utilized. Other circuits disagree. Learned counsel, judges have disagreed on whether or not a right is clearly established such that a jailer or a corrections official should not be able to reasonably rely on the probable cause determination provided to them without looking behind it, holding someone for a day or two, and then releasing them to ICE officials who are going to have that person subject to a removal proceeding.
And so
that's not clearly established. And to hold municipalities, deputy sheriffs liable, in fact, a Virginia court recently in the Western District held that a sheriff was entitled to qualified immunity because even assuming arguendo, the Fourth Amendment was violated when he did not conclude that, but said, even so, I would hold qualified immunity because of the disagreement among the courts. How can we hold a constitutional officer to this when judges have disagreed about holding someone on the basis of an ICE detainer?
So let me break it. Let me break it down so I can understand.
Right.
So we have a federal administrative agent who says to state, local, or local law enforcement,
Right.
you have a man in your custody,
That's right.
and he's subject to what we believe is deportation or
Yes,
some
removal.
sort of removal.
Yes.
And as a result, even though the state's proceeding against the criminal, so to speak, is finished,
Yes.
and the state no longer has probable cause to hold him, which they need to have in order to have the
Right.
seizure, they continue to seize the individual under the Fourth Amendment of the United States. And the question is whether the seizure after the state proceeding is finished is unreasonable in accordance with the Fourth Amendment,
Right.
because there's no ongoing proceeding in the state court to hold him.
That's right.
And then the question becomes, if the state officials hold him and seize him, is it then clearly established as unreasonable seizure?
That's right.
Which then plays into our qualified immunity discussion.
And what you will do in that circumstance is you will get some very highly regarded constitutional professors that will disagree.
Yeah.
And the Fifth Circuit Court of Appeals stated very plainly that administrative detentions have a long history in the United States without a judicial finding of probable cause necessarily, but administrative findings. And they said that state officials could rely on the recitation of probable cause by a trained federal agent who is simply saying this person's not a citizen and therefore subject to removal. So a tremendous area of potential liability that would be placed on, and they're totally acting in good faith. They're cooperating on using principles of federalism with federal law enforcement officials towards a desired end of orderly enforcement, yet would have responsibility and liability over something that is debated. It's those gray areas that I think that a blanket abolition of the principle of qualified immunity would create mayhem.
But the qualified immunity would only kick into play when the detainee brings civil suit,
and they do,
for the seizure that extended beyond their state court proceeding, right?
24 to 48 hours may be reasonable. Any more than that, definitely there's a lot of debate, and we're not sure about the length of it. But yeah, the scenario is what you've described.
So does it break down in a question in practice? Does it break down of a question of how long is clearly established as reasonable, or does it? Is
both.
Is the general decision of seizing someone past?
The argument is that the unconstitutional seizure takes place as soon as the state loses the ability to hold the individual. That is, the command of the state court is to release. To hold somebody on an ICE detainer, and this is happening all over the country right now.
Yeah.
To hold somebody on that is therefore unconstitutional because there's no judicial authority. Most of these warrants, unless there's a federal court proceeding for a second removal, which is a criminal offense. But if it's a first removal, there's not going to be a judicial determination of probable cause by a federal administrative immigration judge. They've decided that, and it's been upheld, that a properly trained ICE agent can make that recitation and states can rely on it. Most circuits agree, some don't. Depends, again, geographically, politically. So you'll have some parts of the country where an individual, jailer or police officer, like holding someone in a lockup for a couple of days, it is liable, but in other places not. And I think that there is a place for qualified immunity when someone attempts to, in good faith, deal with these gray area issues. And I'm concerned that,
And it's just what you're saying, and the way it plays out in your mind is let's give them discretion, and
yes,
and if we're giving them discretion to deal with these gray area issues, let's grant them immunity because the issue is gray.
right.
But if we're bringing that back to an excessive force situation, it's not gray.
It's not gray. And I don't think it's ever been gray. I'm really concerned with some, and I have to say this in all honesty. I mean, the Eighth Circuit granted qualified immunity for somebody that, somebody fell on their head. I mean, listen, if you institute a series of events that are not warranted under the existing fact and conditions, using your training and deploying pepper or whatever, I don't think there's any scenario in this country, and if there is one, it's an outlier that would say, "Oh, that's not clearly established." You weren't. It was not very clear that under those circumstances you couldn't push them, or you couldn't, put handcuffs on them. I mean, the concept of probable cause, the concept of reasonable cause, the concept of reasonable perception of bodily harm. That's where I think that if they sat down and thought about it, and it's a judicially created doctrine anyway, but I think what we were discussing earlier is that statutorily you could do something about it.
And I think what may be difficult is
split the baby.
But how do you and this comes to a kind of a practical discussion, because both of those wrongs, a state seizing a detainee for longer than...
I won't concede it's a wrong.
Okay. Both of those scenarios are implicated by the Fourth Amendment.
Yes.
And the question of whether there's a reasonable or an unreasonable seizure.
Right.
And so in both circumstances, the actual underlying lawsuit is being brought under the Section 1983.
Generally, yes. Yeah.
And so how are the only way to legislatively fix one without the other is to say within the subset of unreasonable seizures on the Fourth Amendment for excessive force claims, qualified immunity no longer applies. However, in other seizure situations under the Fourth Amendment, it does.
The court retains the discretion to determine whether the right is sufficiently unclear such that there's no constitutional breach. I think there has to be a line. When you're talking about constitutional violations, there has to be a test.
But then why aren't we just dealing with that? Why aren't we dealing with the ICE detainee situation on its merits? If it really is a situation of whether it was reasonable or unreasonable, which is the constitutional requirement, and the local official walks into trial, takes the witness stand, and says, I received an administrative order, piece of paper, whatever it may be, that told me that I had the right and was supposed to detain this person for 3 days. And I acted reasonably because that was my understanding of what was
Here's the
authorized.
difficulty. I think the public policy in the law, whether it's in summary judgment under Rule 56, whether it's in the application of qualified immunity, whether it's in the application of the Feres Doctrine, is that you should not have to go to trial, that you should not have to bear the administrative and actual expense of defense of a trial when very clearly, in the eyes of the court, you did not commit a constitutional violation as a matter of law. So there's a screening procedure to guarantee that in every instance there's going to be a trial, absent some other issue that it could be dismissed on procedurally. That's not the desired end. I think that the public policy of at least the federal courts is to marshal the issues and determine if a trial is necessary.
But you and I both know, especially in our federal courts,
right? If
they're even remove the issue of immunity, if we're just dealing with summary judgment, our federal courts love to grant they love summary judgment. It's their favorite thing in the world.
Believe me.
And so
been there.
Exactly.
Yeah.
And so why do we need to give them another reason to grant summary judgment? Why can't they just and for our listeners, summary judgment is essentially before you even get to a trial, a judge saying, listen, there's no jury that could decide other than what I think based
Right.
on the facts. And therefore, I'm not going to spend the expense of our citizens of coming into court and listening to you bozos talk about whatever you guys want to talk
Right.
about when I can make the decision right now. I'm overruling this thing.
Right. And again, I think it furthers a well-entrenched public policy of a federal court acting as a gatekeeper on the facts and the law. And in this regard, I think federal courts believe that they have an obligation to act as a gatekeeper on constitutional issues. And, to hold something like that to the vagaries of how a particular jury feels on every given day, it's then very hard. Isn't it then very hard to put out or define the issue of clearly established rights? I mean, it
Yeah, but
becomes
let's-
very difficult to say, all right, on Wednesday, that jury said that was reasonable. On a Thursday, somebody else might say that isn't reasonable.
But let's strip this and because this idea of discussing it in the realm of clearly established law is judicially created. That is the standard
It's true.
that was created. That's not a constitutional standard. Our Constitution doesn't say that somebody is only responsible under the Fourth Amendment if it's clearly established as wrong. The Constitutional just says if it's unreasonable. And so, or really it says there can only be subject to reasonable search and seizure. And so if we're just adding on another clause to our Fourth Amendment by saying that it has to now be clearly established, why can't we trust our citizens and our jury to interpret our Constitution of what's reasonable and unreasonable without having to create an intervention of a judicially created doctrine that narrows the issues? I mean, we have this in our criminal cases all the time. We say, what's the saying? You'd rather let a guilty man go free than put an innocent man in jail. And I think right now what we're doing is we're kicking all these viable cases out, all these justified cases out of court in exchange for the possibility that we may get some not so justified cases. What's the balancing act?
In terms of the environment of civil redress, I think courts over the years have carved out a lot of different judicial doctrines as screening mechanisms and public policy determinations. And Congress has for many years turned a blind eye to it and have tacitly approved it.
Yeah.
The whole separation of powers issue that underlies whether a series of cases from the Supreme Court can even carve out judicially created doctrine, that's a separation of powers issue that's beyond this discussion.
Yeah.
And to the extent that the court has repeatedly considered it not a violation of the separation of powers and has perpetuated the doctrine, I think it has to be dealt with in a way that's equitable to everyone who's potentially affected by it. And I do see, like, again, I, at the risk of being repetitive, and I apologize for that, but I do see an injustice when it comes to cases involving direct physical force, because that's to sit down in a modern police academy.
You got the guy in Buffalo.
Yeah, I mean, clearly. I mean, and the guy in Buffalo who pushes a 70-year-old man to the ground, even when he's in his face, it harkens back to something that, on a lighter side anyway. I mean, in the scope of my duties now, one day I was in the middle of the pandemic, I was assisting some Norfolk police officers in a situation in booking involving a violent suspect. We had information that this was probably someone who wasn't telling us who they were, but they were probably a gang member out of Chicago. And the person was handcuffed, was in the car, and was relieving himself, had defecated, was spitting on us. And I came upon this talking to the Norfolk officers, who incredibly professional, incredible restraint, because it was at the height of the pandemic and he was spitting on them. And they were very concerned about their own safety. So I entered the scene. I'm 62 years old. I have obviously gray hair. And after arguing with the guy for a while, we did wrestle with him. He was handcuffed, so we could not do but so much. We understood the parameters. You can't beat a handcuffed person. So we tried to get him out. He wouldn't do it. He wouldn't cooperate. We wanted to take his temperature. We were screening him to determine if he went to the hospital, or we would admit him with a temperature. He wasn't going to get admitted to the facility. So I finally just put my head into the vehicle. I had dodged another spittle that hit the door beside me, and I said, listen, I said, I'm old. I said, do you see this gray hair? I don't need this anymore, okay? We just don't need this. You're going to have to go in the restraint chair. You're going to get booked, dude. That's how it's going to end. Come on. Just work with me, and I promise you it'll be okay. Okay. And
that's a human being.
Theretofore,
that's what we want, right? That's what we want.
Theretofore, because we were all like, I just want to, but we knew. That's the culture, by the way. And the culture in my organization, the culture in this other one is to basically, we understand, we'll get to the bottom of it. And this person went in the restraint chair and was done with dealt with, and everybody was okay. That Buffalo officer simply, there's absolutely no way in the world that qualified immunity would be granted in that case. That poor man, if a 70-year-old man confronted me in a riot control scenario, the two of us would be laughing. The two of us would have a discussion. The two of us would be, I would say, I understand where you're coming from, sir. I know you've been through a lot. I know you've seen a lot. I respect you. And just keep walking.
Yeah. But I think,
and that's why I
your
think
statement that it won't be qualified immunity, I think the concern with the doctrine is that we don't know that.
Oh, okay.
We don't know that for certain because we know it's clearly wrong. I think you can watch the video and know it's clearly wrong. But how is the court going to define the situation? Is the court going to say, in light of the circumstances, because there was a riot and there was protests in the area and the uncertainty of whether this man caused concern or as he approached them, right? Like you just don't know. And so if this was an issue decided by jurors, normal people, we would watch it and say, I mean, you've had courts, and I'm sure you've read it, but you've had courts say, I reluctantly grant qualified immunity because of the clearly established doctrine. In other words, they don't even want to do it, but because there's not a case that's identical or very close to the facts, they have to do it. That's the concern.
I understand that, but I believe that those cases are outliers. I think that an individual jurist acting as a gatekeeper would say that is typical of a bunch of actions that would clearly violate clearly established rights to unreasonable use of force, against unreasonable use of force. And, notwithstanding the fact that times are stressful, notwithstanding the fact that many of our police officers in the current situation really do not have a significant amount of riot training, they're terrified right now of what they're facing. But that's no excuse because they have to be the grown-ups in the room. And that 70-year-old man didn't deserve that treatment. So, I don't know how to tell you how to do it, but I do believe that we should try and carve out, both at the state and federal levels, and the state's a whole different ballgame, some sort of doctrine that removes qualified immunity from circumstances involving physical use of force, and to allow the court in its processes to make that determination on the merits.
Well, let's talk about the state.
It's in the state, the state, again...
The state's a little different.
A little different,
because you can bring
no, you can do...
Jurisdictionally, that issue can be in front of a state court, but...
the Supreme Court in Virginia just ruled on a case involving
in January.
Yeah, Cromartie.
Yep.
And it's a case that I've studied and I've sent to my training staff as well as the police department's training staff.
Quick facts of the case: that's a woman who was in a car.
traffic stop.
Traffic
She's
stop.
rousted from the car and
Small
with
woman.
such force, with such force that she sustained injuries simply because she was asking questions about giving a driver's license.
And then the case was brought, I think, per a Virginia code section that's similar to Section 1983, but also Section 1983.
Section 1983, and guided by both a gross negligence and deliberate indifference standard, the Supreme Court upheld the jury's verdict. And there's a clearly established case that we actually train from. It's triage. If you've got a citizen that is not cooperating with you in a traffic stop, there are other ways to handle the matter instead of this type of physical force, which again, they said it, they saw it. There's no question that that was a case for which the jury ultimately should have gotten to the merits on. But there's other cases involving the medical care provided, the degree of medical care provided, the warning signs of an inmate or a prisoner who has a medical issue. There's a whole other category of things involving law enforcement contact with citizens that involves varying degrees of responsibility. And to say that you're going to remove the gross negligence standard and just have a free-for-all when we've enjoyed a significant, if we do our part and exercise good faith, if we happen to be quote unquote merely negligent and we miss somebody who had to get medical care, or somebody slips and falls in a facility, we still don't want to have it open season when I think the system has worked properly.
But I mean, let's put it in another context, which is, you and I as lawyers, we don't have a good faith standard, right? Or
no,
a medical provider doesn't have a good faith standard. Hey,
no, if we deviate
want to
from
do
the standard of care, I mean,
what's the standard of care? What are you supposed to do in these circumstances? And what did you actually do?
Mm-hmm.
Why is it different? Why is it different in state court or federal court for officers than it is for really anybody else? And then not only it's not different factually, it's different legally, which means that you don't even get to that point of getting to discuss what would be the standard of care for the officer in some circumstances or for another government official because of the issues of in state court sovereign immunity, which is in Virginia much broader than qualified immunity. And
absolutely.
And then in federal court qualified immunity. So why is it, and maybe you don't know the answer, but to me, and I think to a lot of people, that's the rub, which is, are we holding police officers and people in public office who we are entrusting with the safety of ourselves and our communities the same treatment under the law as everybody else? That's all we're asking for. That's all I'm asking for.
Yeah, but there's a tremendous difference in the manner in which we have to go about what we do that's different than, say, someone driving down the street and not keeping a proper lookout. There's an enormous amount of discretionary activity that takes place in a correctional setting, on a street setting. The Supreme Court of Virginia held that a deputy trying to figure out how to properly exit a parking lot and pursue somebody was exercising discretion. There are so many rules and regulations that apply to what you do when you're pursuing someone, and you have lights and siren. Are you going to slow down at that intersection? Are you going to speed up? What is the level of hazard that you're dealing with in a correctional setting? What are the warning signs of this person who needs medical care? There is so much discretion involved in that regard.
Why do we just give that? And just for context, when we're talking about discretion, that's because in sovereign immunity world in Virginia, if a government or a municipality officer is exercising their discretion,
right,
they are immune from suit for mere negligence. So you have to prove gross negligence. And for the actual department or the city, the municipality itself, they're completely immune for discretionary actions.
Unless you can establish a pattern of practice. It's not Monell, which would be the federal standard. But there is a standard, I believe, recognizable in Virginia that would establish a policy and practice of the office itself, whether it's a sheriff's office, whether it's the police department being sued through the city on a state claim, not a federal claim. they could still establish that there was a policy or procedure of tolerating that type of conduct, so that there would be respondeat superior liability.
But then when we get your discussion, which is discretion, the discretion
Yeah.
comes into play with, if they are if it's a rule that requires the exercise of
Yes.
discretion, you get the sovereign immunity applies, and it's a different
It's
framework.
a different
of law.
framework. It's a different framework of law, and it has to be, a want of even slight care. You're given the benefit of the doubt, but
But why? That was going to be my
Well,
question.
the courts-
Why are we giving? I understand that there's a difference to me between let's be reasonable in our assessment of somebody's actions. Like, let's not expect too much of them. You don't have to be Superman or superhuman. You don't have to foresee the future. But why do we just, as a matter of law, not a matter of circumstance, individual circumstance, why as a matter of law do we just say, if you've got a choice between A and B, you can choose whichever two you want, and you're practically off the hook?
Again, it has to be that the courts or the legislature determine that juries, can parse out the details and come to a proper determination. And I think that in law enforcement, there's some hesitancy of having every case go to a jury when they may not get the type of analysis of the facts that it warrants. Or we simply trust that the jury will accept the instructions of the court and judge it fairly on just a blanket standard of reasonableness. That would be in contravention of decades of jurisprudence. My concern is this. I think that it's a very complex and difficult job for many, that the public policy issues also include the fact that this is public money. And the Division of Risk Management in Virginia would look at it and make a policy statement in response to any statutory initiative that would mean to abolish all notion of discretion or immunity, and simply say that all cases will be judged on a standard of reasonableness decided by either a court sitting alone, a judge sitting alone, or a jury. There's a cost involved, and societal costs are an issue, especially in the current climate. And I think that the way the system has worked at the state level, using standards of gross negligence, I have not heard an outcry that somehow we have an inability to obtain justice. And my respectful position, but not necessarily an intellectual one, is it's not broken, it doesn't need fixing. In a case involving what happened in Minneapolis, the road to the courthouse would be swift and sure. But in a case involving somebody trying to do the right thing and perhaps making a mistake and violating their training, the court can make the determination and decide if a jury gets to see that. I don't see that it hasn't worked in Virginia for quite some period of time. And I don't know whether or not at this point you'd want to change that and deal with open season in circumstances where it's less clear that somebody acted improperly, that it's less clear that somebody violated their training, so that we can do the best we can and not have to be in fear of litigation and everything we do that would have the opposite effect in our ability to perform our jobs. And I think that's...
But are you really thinking about it? Like, I mean,
Yeah.
You're out on the
every
street
day.
and you're thinking, am I going to get sued
Nowadays,
for
let me tell you something, and I'll tell you from the street level, okay? And I'm not involved in primary law enforcement. I'm not a cop, but I deal with them. There is such fear out there right now of being the one that trying to do the right thing, not Derek Chauvin or whatever his name is. I'm talking about somebody who tries to do the right thing and makes the wrong decision. There is such fear that somebody will be the subject of the next lawsuit, of the next criminal indictment, that they are going to be driven from the communities that they're supposed to protect, that want them there, by the way, that need them there, that they're concerned about being able to perform their jobs without being second-guessed. I'm not talking about a license to commit brutality. Sure. I'm not talking about a license to deprive someone of their liberty or to hunt them down. I'm talking about a simple analysis of facts unfolding at a moment that you do in good faith. At that point, to say that it's open season on every activity of a police officer or deputy sheriff has public policy and societal concerns. And you got to think it through. Because it's nice to be able to say, hey, I was a plaintiff's lawyer. It's nice to be able to say, listen, now I've got a shot at a jury and I might be able to get something from my client. But in the meantime, an officer who believes and their department believes and didn't discipline them that they did the right thing, if a court is deprived of the ability to screen those factors that have worked for a long time, at least in my opinion, and now suddenly it's open season on everyone, I think that everything has to be analyzed in terms of its societal impact.
And I think, and from my perspective, and I don't speak for everyone,
Right, I understand.
But from my perspective, some of the outcry is that they don't feel like it's worked for them, right? Like there are people who probably are looking at the circumstances and looking at the way that this justice system has worked in the past. And while we have different perspectives of whether it's effective or not, there are people who will look at it and say, that hasn't worked for me. There are too many barriers for my day in court. And so that, like, how can we just, for me, it's let's strip it down to what it was meant to be, which is not all these different, hurdles of responsibility for all these different people and immunities and loopholes that people have to jump through. If we want to give an officer a good faith standard, I have no problem with that. But let's let 7 people in Virginia or 12 people, wherever it may be, decide it and let the system figure it out from there, rather than, I can't imagine it's going to be open season on lawsuits. I could suspect that it could be more open season in terms of how far lawsuits progress in the system, and potentially more financial accountability on behalf of some municipalities in order to avoid the risk of a trial in a certain circumstance, whether it's their insurer or themselves. Mm-hmm. But maybe that in some contexts, maybe that's what people want. Maybe people want that additional financial responsibility. They're saying, these are my taxpayer dollars. If we go out and hurt someone, let's pay for it and let's reinvest it in a way that people aren't committing these wrongs. And I know that there's discussion of what's a wrong and what's not a wrong, right? But I think there's an outcry for it's not working.
Well, I see that's where I kind of have a little bit of a disagreement, because I don't think that the national debate right now that's led to this very discussion speaks to a lack of access to the courts for civil redress. It speaks to the street level abuse of authority under color of law. And that can be attacked in a variety of ways, other than dismantling doctrines that, though criticized, have been implemented by the courts in order to screen out constitutional claims. The true issue that has driven this debate, that has only gotten traction in the last little bit of time because of the horrible situations that we've seen. But I can tell you that the situation in Minneapolis would not lead to a lack of access to the courts. You can never bring back a human life, but for those tragically who are survivors, there will be civil redress. There will be criminal prosecution. Remember, Minneapolis had an officer 3 or 4 years ago, a Somali officer. Minneapolis, ironically, has had an enormous diversity program. Yeah. Somali, the two of the officers were rookies involved with Derek Chauvin. They were his rookies. He was their field training officer.
Wow.
2 of them were Asian. But he's doing a 12-year prison term for killing someone without justification, no immunity on the civil side either. The officer in North Carolina who shot a fleeing suspect in the back is serving a 20-year sentence, and the family has received significant redress. I don't think the problem has been lack of access. The problem is simply street-level police abuse of authority, which I think can be addressed in many different ways that don't destroy the applicability of the defense in areas where it has worked that we discussed. Would it be more simple stripping down these judicially created doctrines and just simply go to a reasonableness standard? I'll be honest. I mean, if they did that in the Feary's context, I think that would be fantastic.
Yeah.
But as I sit back, I go, well, if you could allow, every soldier, sailor, airman, and Marine to sue their commander for a decision, there are basic reasons why Fearies exist. And I think there's basic reasons why qualified immunity exists, because a long time ago, it became the public policy of the courts to set forth some gatekeeping standard to determine whether cases proceed and to try and decide whether a constitutional right is violated before we put it into the hands of a lay jury.
And Ferries is,
and I understand your concerns in that regard.
I mean, I think, we can talk about Ferries because it's an interesting issue.
That would be, I think, actually a great discussion for later, because we're going to be filing a writ of certiorari to the Supreme Court.
Yeah. And
I don't mean to detract from this content, but that would be a great discussion.
And I just, for many people, and just for me, not speaking for the many people, I look at it and I think for every one George Floyd that's on videotape, there are many others who may not be as significant, who may not be as severe, and may not be on videotape where the whole world is watching and can outcry and have a situation like there's an Eric Garner where there's a resolution for the family without even having to file suit. There are many others who are interacting with police, like you said, on the street level, who don't feel that the officers are being held accountable. And because of the hurdles, you and I know this. Listen, products liability cases in Virginia, right? The
decisional analysis, it's virtually impossible to get to a jury.
Exactly. And so now you're at the point where lawyers who are supposed to be advocates for these people are their own gatekeeper. Right? So a person comes into the office and says, hey, I want this. This is my case. I think I've been wronged. And you sit there and you've had the discussion. I've had the discussion.
It's a difficult one.
You look them in the eye, say, you were wronged. This was awful.
But
That's true.
There's nothing we can do about it unless the law changes. And so I think for every high-profile case that we can point to in this country and say that justice may have been served in the right way, there are, I don't know how many, and I'm not going to guess as to how many, but there are others where they didn't get the attention. They didn't get the, you have lawyers that are sitting in conference rooms like us across the country who are evaluating them and thinking to themselves, the hurdles are just too high and we cannot be successful. And therefore they're being screened without a day in court, without even being kicked on qualified immunity or sovereign immunity because of the kind of broad scope of the doctrines that it creates this deterrence for people to bring cases for justice. And for me, as a plaintiff's lawyer, as someone who we've talked about represents these people, you think, where would I rather the deterrence be? I'd rather the deterrence be on the other side of the coin rather than deterring the people who think they may have been wrong from exercising what I believe is a constitutional right to the civil courts, rather than the other way around. And so, I think we're on the same page in terms of when we're talking about excessive force situations.
I think so. I really do. I think we are on the same page. I think that we give society great confidence to know that some judge somewhere is not going to engage in tortured reasoning to say that, somebody being slammed to the ground was not clearly established. I think that has outlived its usefulness.
And frankly, I think the Supreme Court, even if it wasn't legislatively, what you said today would probably fix it for the Supreme Court. Because right now the Supreme Court has said, and what establishes clearly established unconstitutional wrong is our great authority and our gavel. But if we can change it to, what if you said clearly established law is clearly established standards of conduct within the industry? That changes the whole thing.
Yeah.
Because then a plaintiff's lawyer rather than having to dig through, Fourth Circuit cases, finding an identical fact pattern, can look at the policing procedures that says don't kneel on a guy's neck for 8 minutes. Right?
It would become a battle of experts.
The,
yeah, it would. And it would also create that type of societal deterrence. I think society right now is ready to deter excessive force.
Yeah.
All right. And has been for a long time. I can say from personal experience that the quality of training in many of the places in this country that have a high volume of police-citizen interaction is stellar. It's a function of reinforcement. It's a function of culture, and that can't be changed legislatively. You can't change the way police think legislatively. It's a matter of leadership. I still think, I read a case before we started here about the Fourth Amendment and a school search, and the Supreme Court considering the reasonableness of a school search. We're trying to keep drugs out of the schools, and a kid comes in, and we have reason to believe that the kid had drugs, and we strip searched a young lady, and it was horrible, and she was scarred. And there was an analysis of school officials and that, and it wasn't clearly established at that time that in loco parentis that we can't exercise something for the minor's own good, engaged in that type of special relationship. And so there are certain areas where I think the doctrine has a place, and certain where it has clearly outlived its usefulness.
Yeah.
And it's the challenge to me, and I think you and I are pretty much in agreement. The challenge is not to go too far legislatively and to cure the evil at hand. And that is, what's the problem right now? It's the lack of confidence on the part of a segment of the American populace that has had incredibly bad interactions with police over the years, that there's a lot that needs to be healed in that regard. And the best way to do it is to allow the cases to go forward, absent, I didn't do it, or some substantive defense
that could be resolved otherwise.
I didn't do it. It wasn't me. I wasn't. Those traditional defenses don't fall away. It's that the jury gets a chance to hear it, and we don't have these tortured reasonings, because I think police departments need to take, and sheriff's offices need to take responsibility for that training. And if they want to defend their officer, they'll do it. And then it becomes a subject of, that'll cure the whole issue. And you've got your Civil Rights Acts and your Hate Crimes Acts, and you've got so many procedural and substantive protections for the true problem that brings us here. But then there's case after case of these more difficult cases that I think there should be a determination made that maybe the individual actor and their department is entitled to protection because of the gray area. Again, I think what you say makes a lot of sense, to keep our system simpler and just use a reasonableness standard for everything, but I don't think we're there yet. And I think that there's a lot of having to convince courts that are entrenched in decades of stare decisis that there's something that they're going to have to change right now.
Yeah.
That's for the legislatures to do. They're more likely to do it than the courts. And I hope they don't engage in a knee-jerk reaction like they've done in the past. And then we're turning out. I don't want, and I totally respect your position on it, because you're involved in representing people that have been harmed, and I get it. I don't want, from a public policy standpoint, a system that is so retributive in terms of going back and
hindsight,
righting
2020.
wrongs that took place 20 years before that officer went on the street, that officer then is deterred from protecting the public because they want to do their 8 hours, never take their weapon out, never be proactive, never protect a community with proactive policing, never stop anybody and question them, and simply, okay, I'll take my public money and I'll go home. And therefore, the citizenry that need it the most do not get policed. And that's one of the public policy reasons why legislation needs to be well thought out. And I say that respectfully.
Yeah, and I think your point is, in terms of the court, because if we look at our court makeup right now in the Supreme Court, the chances that I don't think that qualified immunity is going anywhere, even though they may take it up and may chip away. they may chip away somewhere.
I
but
think
you're gonna have
Gorsuch and
just
Kavanaugh might
think
give
so?
it a look. I mean, they're not going to
Thomas
be.
is going to tell the legislator to step in.
Thomas has said that they've taken qualified immunity well afoul of the common law. They've
Yeah.
taken it in a place that he didn't determine it.
Yeah.
You know, Kavanaugh and Gorsuch, I don't know. They you know, they're not going to be in lockstep with what Scalia. Scalia was a champion of it, I believe. But I think
Alito
Kavanaugh
will be a champion of it.
I think so, but I think Gorsuch and Kavanaugh might be wild cards in this regard. Maybe Roberts will jump in with
Well,
them.
maybe you get to argue in front of them for Ferris, or maybe
I'd love
both
to,
of us.
That would be fantastic. By the way,
Ferris is just for, and we can talk about it.
I'd
a
like to
little
do
bit.
that on another occasion.
Let's do it on another day.
Yeah, but
Yeah.
I mean, if you want to set it up briefly, but this firm is going to be involved in something that could change the lay of the land because we've got the right facts. The question is getting them to take it.
Yeah.
But I think that qualified immunity is going to be very interesting from the standpoint of Kavanaugh, who I don't think he's going to be a slam dunk for the process. I think he's going to be very fair about it. I would like to see what they do. But they're going to have to walk away from decades of jurisprudence.
Well, I think that they're gonna what the benefit. It's not a benefit. I mean, they've decided some of these cases in the last 3-4 years.
They have.
But they've decided, the majority has decided them sort of just consistent with procedural. Yeah, it wasn't clearly established, and it's done. And so the question now becomes, how do they? I think the easiest judicial fix is redefining what's clearly established.
Or Congress will do something that moots or renders obsolete the previous rulings, and it's a new ball game.
Our guy Justin Amash,
he
tweeted about it. I'm looking at my phone because I thought he
did tweet about it, but he also did something bizarre. To be a libertarian is a good thing, but to be a libertarian and lose the forest for the trees. Amash was one of 4 votes in the entire House of Representatives against the lynching amendment to the federal civil rights statutes. And Rand Paul is doing the same thing in the Senate on technical grounds. Any federal judge is going to know what's meant by that legislation. They're concerned that, bruising might give you 10 years behind bars. That's a canard. I think that the libertarian look at this. Amash, who's an independent libertarian, and Ron Paul, libertarian, are saying that the lack of procedural due process in the enactment means that it shouldn't be passed. But I think that the great picture needs to be looked at. So Amash, he does a good thing on one day, but in my opinion, this vote in the House establishes him as an outlier. To say that you can't have a lynching provision in the federal statute that talks about violating someone's civil rights, to me is I don't get it. I mean, I think that's a hyper-technical analysis, and he should fight another battle. Like it was, I don't know how many people in the House of Representatives were 4 people, and he's voting with Louis Gohmert. I don't think I would not be proud of that. You know what I mean? I would not want to say I voted with Louis Gohmert on an issue. I'm sorry, but that's where you lose
let
me.
dead fish die.
Exactly. So I mean, it's been great. Listen, after a career in the law, I think that any time that a plaintiff lawyer gets to stand up in front of a jury and argue their cause is the essence of what this country's about.
Yeah.
But it can be complicated in certain areas, and I think there's times that public servants should not have to face the scrutiny of a jury if the court feels that the actions fell within the parameters of either the framework of, is it gross negligence or not, is it deliberate indifference or not, where they have their traditional summary judgment
Those are
role.
factual. Those
Right.
are factual
and they can
distinctions.
still take the case from the jury. But the whole issue of qualified immunity and the clearly established rights, I think, would protect people acting in a world where some courts say it's not right, some courts say it is right. What am I supposed to do? I need to make a policy decision.
Just the way it's working right now is we're in the 4th Circuit in Virginia, right? Let's say there's a decision in the Eastern District of Virginia, and they're looking at what's clearly established. Mm-hmm. According to the case law, they can't even look at what happened in California.
Yeah,
they're only supposed to look at Supreme Court cases, and circuits are split on this. Some circuits say you can look at whatever state, but like it's like you're saying, not only do I have to find another case in the United States that's very, very similar to the facts of mine,
Right.
I have to find it in North Carolina, West Virginia, whatever, in my region. And so,
Well, to take it to its absurd level, I believe there's a split between the Eastern and Western District of Virginia on issues involving the ICE detainer. I mean, even district courts disagree. So to say that constitutional rights were violated by a good faith actor who's just trying to be, a team player in the whole federalism context, that to me would be an injustice. So I think that, again, it has to be carefully thought out. And going back to the whole situation, we want to prevent people that are abused by police in the arena of excessive force. We certainly want them to have the redress. It becomes more problematic in terms of warrantless searches.
Yeah. But the
Supreme Court for a long time has stated that there's a good faith exception to the Fourth Amendment. We're going to turn around and now say that anytime there's a Fourth Amendment breach because a warrant wasn't obtained, even though they thought that they were able to do it, that person would have civil redress. I mean, again, it gets really complicated, and we're outside that arena that really led us here, and that is the violence.
Yeah, and this as well as I do. Ultimately, what you want to do is prevent.
Absolutely.
I think everyone, the first priority would be, let's stop this from happening.
Yes.
But you and I think would agree that the closest thing to justice when you can't prevent it is getting someone some sort of compensation.
Absolutely.
Or some sort of redress for what they've been through. And right now, in cases of excessive force,
yes,
that's not happening in really either direction. People aren't confident that it's being prevented in the streets. And some people aren't confident that they're going to get their redress in the courts. And so that's what I think is maybe causing some of the social discourse, which is, which way do I turn for my country to look after me?
No, you're right. And it's the onus. It is now the onus is on the leadership at the various police departments and sheriff's offices in order to continue to create cultures of confidence in the public. There's a lot of concern about the protections of collective bargaining, that civilian oversight and civilian input into disciplinary processes, into internal affairs. All these are great ideas that can also prevent the problem, all right, or at least deal with it without having to tamper with that delicate framework of the law for the last 4 or 5 decades or more. So I think that there's going to be a tremendous onus on the part of managers, police chiefs, and other officials to say, we want to establish this confidence. I can say, from what I understand from my position within law enforcement, that these are outliers. That thankfully we can be confident that the vast majority of American police and deputy sheriffs do not get up in the morning with a notion to harm anyone. Mm-hmm. That their reaction to stimulus in the field, resisting arrest, is a function of their training or lack of training.
Yeah.
And it's our onus to train them and to make sure that they go out and use the skills to give the public confidence. And I was taught that my best weapon, and it worked for me that time, is your voice, mm-hmm. and your reason and your ability to instill calm and not escalate.
Yeah.
And 90% of the American public will respond to police respectfully and accede to their authority, and the citizen police encounter will go without incident. That's what we want.
And I think the irony of the situation right now is that we have discourse in the country that was caused by a situation that didn't meet that, right?
Not even close.
And then we're seeing additional incidents like the Buffalo,
yes,
where we think where it's reinforcing the wrong message.
That's right. And
where the spark that lit the fire was something that was deep inside of
mm-hmm.
concerns of Americans, and then as the fire's burning, people are just spraying gasoline on it.
And here's the converse of that. And again, it can never justify any individual excessive use of force. The video of a New York City police captain who's trying to stop looting is physically dominated and thrown to the street by a looter. Officers have been shot. 2 Richmond police officers were shot early in the week.
I saw that story.
One is fighting for his life.
Yeah.
Deaths have occurred. The police are terrified about what will meet them on the streets because they believe there's an element in this that is bent on nothing short of revolution, and it becomes terrifying for them. But that's where the training kicks in. They are the adults in the room. They went through the physical training. They went through the emotional training. They took the psychological test. That test does not tell you to throw a 70-year-old man to the ground.
Yeah.
That test does not tell you to stand on someone's neck for 8 minutes. That test does not tell you that you have authority to strike above the shoulders unless it becomes a deadly force scenario. And when you lose that, you get where we are now. And debates like this, and I can assure you, every legislative house in every state is going to deal with this issue, and Congress is going to deal with it. And what comes on the backside, I just hope that innocent people in the communities do not pay the price for this.
Sure. I mean, ultimately, we want everyone to feel safe in the streets.
I mean,
officer, citizen,
and citizens.
Doesn't matter. And so either way, I think people don't feel that is what it is right now, and you hope that one way or the other, either that's where we get, or our ability to seek redress when it doesn't occur is improved,
is
established.
Established, yeah. Because I think that's just as much a deterrent. If we were put in a situation, law enforcement was in a situation where, in all circumstances involving excessive force, you better plan on, making your case to the court to try not to get to a jury on the merits. I guarantee you there'll be additional deterrence.
Yeah, and that's what
I think that solves the problem without drawing in this other stuff. That it's I think it's still a necessary doctrine. I don't think it's totally vestigial. Some really smart Cato scholars would say otherwise.
Let's not let the perfection be the stifle progress, and maybe if those issues, if the ICE situations or other issues aren't what's really creating this discourse right now, maybe we can table it. And then if it becomes out of hand, like the excessive force situation, it can be dealt with at a later time. Yeah. But for now, I think we both agree that the excessive force situation has gone over the edge where there really isn't, it's so clearly established what is or is not wrong that the courts need to stop butchering.
I think so. And you can't, Justice Thomas made the comment, you cannot weave any thread of commonality in these cases. And that doesn't give anybody pause. I mean, it doesn't give anybody
There's
guidance.
So much ambiguity.
Putting your hands on someone is either very clearly justified or it isn't. Putting your hands on someone and causing them serious bodily injury is either justified or it isn't. To say that something's not clearly established when it comes to one human being engaging in physical combat with another person in the context of making an arrest or in the context of an investigation, I'm sorry, but I don't see the basis for it. And maybe that'll stop some over-aggressive legislators in their tracks if you try and get them to split that baby. And that's the hope, because I don't think a lot of police officials in the country would disagree with that notion. Yeah. I think they're the first ones. You might not believe this, many people, but they're the first ones to take their people to task. I know local police departments that even if a use of force is signed off on by the street sergeant, it goes to professional standards for review and they'll kick it back. Mm-hmm. I spent many years representing police in grievance procedures that were either fired or severely disciplined for using force. I don't think, at least in our area, there's a culture of tolerating excessive force. But I know that there may be cultures in other departments. I'm pretty certain of it. And therefore, I think that the bottom line is a citizen should have their right to establish to a jury of their peers that excessive force was used without the intervention of this doctrine. And I hope for the best. I'm certainly not hoping that the pendulum goes so far the other way that they tear it all apart and then create a liability scenario that creates mayhem within law enforcement.
It's fair.
Cool.
Mike,
Thank you.
thank you.
As always, a pleasure. Let's do Furies next.
Let's do fairies.